Signing a contract without understanding your role under the contract can cost you millions, or even your freedom. In the world of legal agreements, ignorance is not just dangerous, it can also be expensive. Mr. Bayo was a successful businessman in Lagos. He accompanied his old friend Kunle to the bank. Kunle was applying for a 20 million naira loan to expand his electronic business. The bank manager asked Mr. Bayo to sign the loan agreement as a witness. Mr. Bayo signed the agreement without taking a close look at the document. He believed that he was not involved in the loan and that he was just there to support his friend. 1 year later, Kunle's business collapsed and the bank came knocking, but not on Kunle's door. They came for Mr. Bayo. Mr. Bayo's signature, which was just placed beneath the guarantee clause, made him liable under the contract as a guarantor. The bank sued him for the recovery of the loan and he lost millions, not because he took a loan, but because he signed without understanding the capacity on which he signed. Let's talk about the difference between a guarantor and a witness in contract execution. A witness in a contract is simply someone who observes the signing of the agreement. Their job is to confirm that the parties involved signed voluntarily and were not under duress. A witness doesn't have a stake in a contract and they don't owe any duty or obligation under the contract. Their signature only validates that the contract was duly executed. If you're signing a contract as a witness, you're not liable for the terms of that contract. However, you could be called upon to testify in court to confirm the authenticity of the signatures or the circumstances under which the contract was signed. Let's talk about the guarantor, and this is where things really get serious. A guarantor is someone who undertakes to pay or perform the obligations under the contract if the primary party defaults. In every contract or agreement, a guarantor has a binding legal obligation. By signing as a guarantor, you are simply saying that you undertake to be held responsible if the principal party fails to perform his or her obligations under the contract. As a guarantor, you are directly liable, and if the borrower fails to pay up the loan or if the contractor fails to perform their obligations, the other party can come after you, your assets, your income, and even your credits. Many people sign contracts as witnesses but are in fact treated as guarantors because they signed near the guarantee clause or because their names appear close to clauses imposing obligations. In contract law, your signature is your bond. Don't let friendship, pressure, or ignorance lead you into obligations that you never bargained for. Always read the contract, check what you're signing for, and if you're not sure, don't just sign, talk to a lawyer. A witness is very much different from a guarantor. If you're ever asked to sign a document, think twice, know your role, and understand the risk you're opting for. Go ahead and drop your questions in the comment section below. Don't forget to share this video, give it a thumbs up, click the follow or subscribe button to stay updated whenever I drop a new legal update.